Camus argued that the legal individualism at the heart of the revolutionary Jewish enfranchisement was not altered by either Napoleon or the Charter of 1814, which Louis XVIII promulgated as a new constitution soon after the Restoration. Even if the new constitution had reintroduced Catholicism as the state religion, Camus fought to have the state uphold Clermont-Tonnerre's promise and framed the matter in terms echoing the revolutionary Declaration of the Rights of Man. All titles, all statuses, all religious denominations are erased before the majesty of the law. Sovereign master, the law rules over all citizens equally, and it must be applied equally to all. Despite Camus' efforts, it was not until 1846 that France's highest court, the Court of Cassation, would rule the practice of the more Judaico illegal. However French citizenship played out in practice, in theory it was meaningful only for the Jewish individual. This was also the case in the newly founded United States, where Jews, specifically Jewish males, were included as individual citizens by virtue of not belonging to a group that was excluded from citizenship, though a small number of states, such as Maryland, restricted public office to Christians well into the 19th century. How historians have understood the degree of Jewish rights in a society since then has largely been measured according to this Franco-American yardstick. Political and judicial systems that make the least distinction between Jews and non-Jews are seen as the most enlightened or emancipated, and those that do make legal distinctions between Jews and non-Jews as the most discriminatory. Leaving aside the reality that Jewish civil equality could exist alongside Jewish collective rights, in both places a degree of deference to religious tolerance and the continuity of certain legal traditions, or in France continued prejudice, preserved the Jewish collective as a legal category. In post-revolutionary United States, as in France, exemptions were made early on to generally applicable laws. For instance, in Rhode Island, the state legislature passed a law in 1798 affirming an earlier colonial law exempting Jews from laws prohibiting marriage between an uncle and his niece, a law that remains on the books to this day. While this small exception is hardly an expansive collective obligation on the scale of the debts owed by French Jewry or a privilege on the magnitude of the Kiryas Joel school district, the point is that Jews have been treated as a group requiring accommodation since the early days of the American Republic. In France, the inverse was true. The state itself reversed some of its egalitarian principles vis-à-vis the Jews and in several ways preserved the distinction between Jews and Frenchmen, as it did between Catholics and Protestants. Furthermore, Jews have not tended to seek in the United States and France fewer accommodations to their collective rights than in other states, including the Jewish state itself, modern Israel.